Hello, everybody. Just waiting for a few more people to join. If you're joining us from the US, good morning. I understand that it is bright and early over there. And if you're joining us from the UK, good afternoon. My name is Abigail Smith. I'm an associate at Fenchurch Law, and I will be your moderator for today's session. We might as well start with a couple of housekeeping points whilst people are continuing to join. The session will be recorded and all registrants will receive a link to the recording and a copy of the slides tomorrow. If you do have any questions during the session, please do pop them in the chat box, which you'll find at the right of your screen, and I will keep a tab on those as we go along, as I'm sure Joanna and will too. Moving on to much more interesting things, we are joined by Will Bennett, partner at Sachs, Stoneberger and Vita, and Joanna Grant, managing partner of Fenchurch Law. Fenchurch Law and SDV have been working increasingly closely together over the past year or so. And it was early last year that Will and Joanna participated in a panel discussion about the similarities and differences in the process of resolving disputed insurance claims in the UK and the US. They were both so taken by those differences and had such fun talking about it that they decided to open up that discussion to a wider audience. So here we are. In this session, Joanna and Will are going to comparatively examine the anatomy of an insurance dispute from start to finish, focusing on the procedural differences, the substantive distinctions, the practical factors, and strategic considerations. So, Joanna and Will, welcome and thank you for joining us.
Thanks,
Thank you,
Abby.
Will, starting with you and starting at the very beginning, I guess. Can you share an overview of the pre-litigation process in the US? I was reading about this earlier and it seems incredibly complicated from a UK perspective.
Yeah, sure. And this is fun and exciting. It feels like the culmination of a long process of discussing this topic. Like you said,
Mm.
we did this as a presentation a year ago, and now we've done an article and culminating with this webinar for the world. This is pretty cool. I am still seeing the title slide, just so you know. So
Apologies. There we go.
let's go one more to that. Yeah, there we go. So,
Are we there? Good.
yep. Um, when we first started, well, now I'm seeing, sorry, now I'm seeing, there we go. We're good. Okay. Um, when we first started talking about this, it actually was really trying to decide what we should even present on last year when we were at this stage of getting ready for our SDV Summit, which our friends at Fenchurch, who were new friends at the time, were going to come join us for. And I got the wonderful task of figuring out a panel to do with Fenchurch and with Joe. And we talked about some stuff and realized that we were both very interested, just kind of generically, in each other's processes and how different. I knew little bits about the UK system. I knew about the idea of a barrister versus a solicitor, but much that I didn't realize about the differences between the systems. And then as we started talking about it, it occurred to me how impactful those differences are and must be in the way that claims begin, the way they mature, the way they ultimately get sort of adjudicated. Um, and then, over here as a US coverage lawyer, I deal with London a lot, London markets. And it's a different experience dealing with London markets. And I started to kind of connect the dots as to some of the reasons why some of the expectations are different and the way things are handled are different. And so it's just been a really interesting exercise, and hopefully you guys will get a little taste of that as we go through these slides. But um, we kind of have this chopped up into the different stages of a dispute. We call it the anatomy of an insurance dispute. So we start in this pre-litigation phase, early considerations before there's litigation happening, and then we kind of mature all the way up to trial. So we'll go through that kind of back and forth, US, UK, UK, US, and reflect a little bit as we go. But um, the US perspective on this stage, the pre-litigation stage, I think is one of the most important things about understanding why the US system is the way it is and what it is. And it starts at the top in a way, which is to say that there's an act called the McCarran-Ferguson Act in the US that is a federal law that says the federal government is not going to regulate insurance. So when I say it starts at the top, what I really mean is the top says we don't want anything to do with this. And now we move to the state level, and each state now has the power and authority to regulate insurance however they so choose. And if anybody has, anybody here certainly knows, but anybody abroad who pays any attention at all to news about the US knows that our states don't see things differently or don't see things the same. Excuse me. They see things very differently. Um, and obviously that would be all political issues, but uh, surprisingly, insurance issues wind up the same way. So we have, 50 different states all applying their own, not only their own legal principles, their own, differing degrees of regulation, their own differing approaches to regulation. You have a lot of things that all states will do, certain homeowners insurance regulations, things like that. And there's variation among them, but you'll at least find probably those laws everywhere. And then there's insurance law that some states have a body of statutes that address this whole area of insurance law, and other states have nothing. And so you're left with uh, a- navigating the web of different courts that exist in the US, which we'll get to in a second, to fill in those gaps where the state itself has not said anything. Um, the courts then are a whole separate layer of complexity, right? Because, like I said, 50 states, um, every state's courts are not bound by any other state's courts. They're only bound by certain courts within that state. Um, and then on top of that, every state has federal courts. And those federal courts are tasked. You can't always bring a case in federal court. You also can't always, well, you can always bring a case in state court. You just might not be able to keep it there. But you can't always bring a case in federal court. It is common in insurance cases that you can for um, reasons I won't go into. But anyways, so you've got state courts making state law, and then you have federal courts who are tasked with applying state substantive law and federal procedural law. So theoretically, all, if not at least almost all insurance law is substantive in nature. So theoretically, the federal courts are tasked with applying the insurance law set by the state courts. Except there's a lot of different issues in insurance law, and many of them, especially when you leave the Californias and the New Yorks of the states and you get into the Kentuckys and the Montanas, a lot of those issues haven't been addressed by courts at all in the state courts, and especially in the state courts because the insurance cases are more prone to winding up in the federal courts. Which means that those federal courts are now tasked with not applying state law, but predicting state law. And so you wind up with this body. Another fun distinction is the federal trial courts publish their decisions, which the state trial courts typically don't do. So your, summary judgment opinions and motions to dismiss opinions, which are really early stage things in litigation, at least compared to trial or like going to an appeal, as you would usually see in a state court piece of case law. Those are all available for lawyers to see what judges said, cite to, try to convince courts that they should do this. So it just winds up being an incredibly complex web. And then you add on top of all of that, that companies in the US are very strategic about where they incorporate, where they headquarter, where they issue their insurance policies, things like that, um, for reasons usually not related to insurance, usually related to taking advantage of better corporate laws or where somebody's located or whatever it is, um, throughout the country. But those considerations, where is a company incorporated or domiciled? Where is the company headquartered? Where do its executives sit? Where is its broker? Where is its insurance company located? Those are all considerations that go into what the correct choice of law is for the dispute that you're having. And so you might be dealing with, um, a New York insured who's building a project in Texas with an insurance company headquartered in California that issued the policy that's in play, um, and maybe a broker in Chicago. And so now you're thinking to yourself, okay, we've got a denial of coverage. We're gonna, we feel inclined to fight about it. Where do we go? Where do we bring this fight? And that exercise, which has got to be done ahead of time, because once you make your decision, you're stuck with it, is going to involve looking at every single one of those venues. Let's look at California, Texas, New York, Illinois. Um, Try to decide which one has the most favorable substantive insurance law, um, best principles for your particular situation. And then you also then have to look at each state's procedural considerations and their choice of law rules, because each one of those states is going to have a body of law that says these are the considerations I'm taking into account to decide which state's law applies. A court in Texas might decide that California law is the most appropriate law for a particular dispute. So you've got to go to every single one of the states that you're considering, try to evaluate what law they're going to apply, compare that to the law you think is best, and try to land on one that's going to give you the optimal set of results. It's a very front-loaded exercise bringing coverage litigation in the U.S. And that piece of it makes it a really unique practice. I sit in California, and I am to an extent a California coverage lawyer, but equally as much, I view myself, and I think all the lawyers at SDV view themselves as national coverage lawyers, because we're dealing with companies that do work all over the country. And we run into this all the time, especially our construction clients. They build projects all over the place. Some of those projects are insured by policies that are meant to insure their risks all over. Some of them are insured by project-specific policies. That's two completely different considerations in terms of choice of law and where we can bring a dispute. On top of that, as if we needed more considerations, you have this concept of bad faith in the U.S. Anybody who's on this who's from the U.S. will be very familiar with that. But this is basically the idea that the courts basically create this sort of a legal fiction that says, implied into every contract, including an insurance policy, is the obligation to deal in good faith, or the implied covenant of good faith and fair dealing is often what it's fully articulated as. And if the insurance company doesn't just deny the claim, it's not that, but if they deny the claim subject to sort of an elevated set of criteria. And it's hard to say one particular standard because it varies from state to state, and not all states have this either. But for example, in California, basically, if there's an unreasonable withholding of benefits, not subject, the denial wasn't subject to a genuine dispute, then you could potentially recover bad faith damages from the insurer. And again, talking about pick your state, pick your law, that's going to be most optimal for your situation. That remedy for bad faith can range from California. Generally, you're just going to get your attorney's fees incurred to bring the coverage action to, there are treble damages multipliers in certain property claims in the Gulf Coast, especially. So, the insurer commits bad faith in the course of adjusting your claim, takes too long to pay it, takes too long to adjust it, whatever it is, you could get hit with, the value of what the claim was tripled. Not all the slides are this meaty. This particular slide is really hefty, so I'm almost there, but we'll turn to Joe in a second. So another distinct, and I bring this up as a point of distinction, as you'll see um, when we hear about the other system, but the U.S. barrier to entry in litigation is incredibly low. Yes, there are extensive costs that are incurred during litigation, but the actual like process to bring the case, you don't even really need a true denial of coverage because we have the ability to bring declaratory judgment actions, which asks the court to just look at the policy and determine what the party's rights are under it. You don't even really need a breach of contract per se to bring an insurance case. You don't have to educate the other side extensively on your position. You don't have to put an enormous amount of detail in your complaint. Typically, it depends a little bit on the state, but typically, you just have to give them enough information to have a general idea of what the case against them is. That's the standard for your complaint. But you don't have to do any of that before you file a complaint. The complaint could be, other than tendering the claim to them, kind of the first time they're even really exposed to your position. Um, and I think the lack of fee shifting, which again, you'll hear about the UK's perspective on that in a minute, but I think the fact that there's no risk of the other side, especially as the policyholder, a little bit of a risk as the insurance company, but as the policyholder, basically no risk that the insurance company is going to be able to recover their fees. And again, just for the people in the room who are saying, well, what about there are little state exceptions here and there to that rule, but generally speaking, policyholder's not going to be at risk of having to pay fees. So it's a easier bar to entry. Let's hear about something other than what I have to say.
Thanks, Will. It's a complex web, I think, as you say. Joanna, I think you'll agree that there are some key differences with the UK process there, especially in terms of the market and our approach to litigation. Can you share what those differences are and if there are any similarities?
There's a few, but not many. This is just. I mean, it was mind blowing for me, and I think we're just all so used to operating in our own bubbles and accept it as just the way the world is, and I just found it so very interesting and yeah, mind blowing to see quite how different it is. And as I was saying to you earlier, Abby, I just feel so lucky that we have only a single body of law that's applicable in England and Wales. I honestly don't know how Will and his colleagues do it because I find life hard enough with just the one body of law.
Yeah.
And I think the other real standout difference there is the lack of concept of bad faith here in the UK. So just like in the US, it is the case that our insurance contracts are contracts of good faith, but in fact that almost spins out in an opposite way because how that plays out in the UK is really through the duty of fair presentation and the onus is really it's all about has the policyholder provided the documentation to make a fair presentation of the risk and the consequences that the policyholder faces if it gets that wrong. Whereas it seems that in the States, it's the opposite. The onus is very much on how has the insurer handled the claim and has it discharged its duties in terms of a fair handling, if I can summarize it as that. So that was really, really striking to me because it seems to be at the heart almost of the approach. And often, I think there's a perception that's very much grounded in at least in an historic reality that the UK was a much more pro-insurer forum and that the States is a much more pro-policyholder forum. And I think that still holds good, although certainly the introduction of the Insurance Act almost 10 years ago, would you believe, has ushered in a more policyholder friendly era, and the insurers are no longer able quite in the same way to decline claims for breaches of policy terms. And I think the other thing really to pick out here is that the fact that the centre of gravity for the insurance market in the UK is certainly focused in on the Lloyd's building, which I can see just about outside my window here. So of course it's practiced nationally, but really the centre of focus is London, where all the insurers, brokers, law firms are all within one square mile in the City of London, which I think we're apt to forget quite just how large the states is. And it does mean that here people, within the market, it's a small world, and I think that's another striking difference. And then finally, just picking up on the fee shifting. Of course, here in the UK, the loser pays the majority of the winner's costs, and I think that does really change an approach to litigation. I think it's one thing to go into a court fight thinking your fees are under your control to an extent, whereas of course here the risk of adverse costs very much does make for a more conservative approach to litigation, just because the stakes are so high.
Yeah.
All right. I think
I have a question for you,
yeah,
Joe.
far away.
So the Insurance Act of 2015 seems to be kind of a demarcation between a more pro-insurer landscape and at least a slightly more pro-policyholder
Right.
landscape. Like, what do you think? And I apologize, I did not give you this question ahead of time, but what do you think? What was the headwind that precipitated that passing and that shift?
I think it was just very much a sense of the fact that it was just so pro-insurer for such a long time, and that it was, very, very easy for an insurer to decline a claim, and that there was a need for a rebalancing, as it were, and therefore a process was gone through to look at what might be a more proportionate approach, and bringing in these proportionate remedies so that an insurer's ability to decline the claim or pay a lower amount was very much moderated by reference to the nature of the breach. Now, I saw a hand up there from Tom McGrath. I don't know if I'm able to bring up that question, or if Tom, if you're able to speak up.
We do have a Q&A box too, where I think you can enter questions, which we are monitoring.
Yeah.
And please feel free
Yeah.
to do that. We're happy to address questions as we go.
Great.
You might
Okay.
need to put your question in the box, Tom.
Right. In the meantime, Abby, do you want to take us to the next section?
Yeah, sure. So if we stay with you, Joe, recognizing that the majority of UK insurance disputes settle in this pre-litigation phase, and that it's arguments around policy interpretation that often drive outcomes, can you share how the courts approach policy interpretation in the UK?
Yes, I absolutely can. So this is one of my favourite topics, actually. The English courts take an objective approach to policy interpretation, and they ask what a reasonable person with all the background knowledge that would reasonably have been available to the parties when they entered into the contract would have understood the language of the contract to mean. However, the subjective intention or understanding of the parties as to what the policy wording means or is intended to achieve isn't relevant to that exercise. But that said, and this is where we already begin to come into differences, as will take us to, market practice or understanding, if it can be established, that can form part of the background knowledge that would have been regarded as being reasonably available to the parties. When we come on to issues of commercial common sense and ambiguity, Uh, Certainly, commercial common sense is not permitted to be invoked retrospectively to rewrite a clause in an attempt to assist an unwise party and help them out of their commercial mess. Where the parties have used unambiguous language, then the courts will apply it. And in recent years, and this is perhaps more like the US, in recent years, the courts have been taking an increasingly strict approach, making it clear that it's not their job to rescue a party from a bad bargain. And if the wording is clear, then the courts will apply it. Equally, however, if the wording is unclear, and there's some ambiguity, there's two possible constructions, then in those circumstances, the court's entitled to prefer the construction which is consistent with business common sense and to reject the other. And particularly in the context of insurance contracts, we have the doctrine of contra proferentum, which applies, and so that where there is that ambiguity, the clause can be interpreted against the party responsible for the drafting. And this is certainly my favourite case of recent years in terms of constructions that help a policyholder. And this was a recent ruling in the case of Marrickville and Swiss Re. And in that case, it was held that a construction which advances the purpose of cover is to be preferred to one that hinders it. And that's certainly part of the pendulum swinging in the policyholder's favour, which is what we like to see. And finally, just picking up on that last phrase in the slide there, pick and mix. So pick and mix, that refers to the fact that policies are often made of different clauses all bolted together. And that fact can be taken into account by a court when it is looking at how to construe a policy, because it may mean that there's insufficient consistency between the terminology of different clauses to use one as an aid to interpretation of the other. So that's a quick run through from a UK perspective.
Perfect. Thanks, Joe. Before we move on to Will, we have a question in the question box from Tom McGrath. And I guess this is for both of you, but particularly Joanna. Has the Insurance Act been watered down by proportionality? For example, underinsurance, when there is evidence of underinsurance in a property claim where the insured has suffered a total loss?
Well, that's a very good question. I think I think it hasn't. I would certainly say that there is still very much too weighted towards the insurer, and also that we are not seeing. I've certainly in the last 10 years of the Insurance Act, I have not seen, although others have, but personally, I haven't seen a single occasion of an insurer suggesting that a proportionate remedy should apply. So,
Okay.
yeah, I think there's still a long way to go, is what I would say.
Understood. Going back to policy interpretation, Will, I'm going to go out on a limb here and assume that the position is different in the US.
Well, it's really interesting because I feel like we use a lot of the same words, but we don't use them. We don't land in the
Yeah.
same place with them, or they don't get applied in the same way. Yeah, the one thing, one of very few things that I would say really all states' insurance law in the US agrees on is that you start with the plain language of the policy. If there's a dispute over whether there's coverage, the courts pretty much, if not everywhere, will start by going through the exercise of looking at the language in dispute and trying to understand what it means. And by and large, I think they genuinely want to figure that out. That is my experience. They want to, it's a principle that runs through all contract law in the US. They want to figure out what the intent of the parties was from the language in front of them. And all these other rules and such and these other bullet points kind of all stem secondarily from that. But I want to emphasize when we talk about the plain language of the policy, the courts here typically think of that very literally. This piece of paper in front of me, what does it say? I don't care that you guys both have a commercial understanding of what it means. I don't care that there's a whole bunch of evidence about what you meant for it to mean. I don't care that there are 17 other policies that you have that you could show me how the insurer could have done this provision in a more restrictive way or a less restrictive way. I don't care. All I care about is these words in front of me. Can I figure out what they mean without looking at anything else? Um, and I think one of the things that this exercise helped me with was understanding why the London markets, in particular, struggle a little bit um, with the U.S. not caring about intent, not caring about some of the extrinsic evidence or what the broker said. It doesn't matter if the court can look at the policy language and say it means this and only this. And I think the court generally wants to do that. So it is it is tempting for new coverage lawyers in the US to see that many of our states have rules that say when we can't figure out the plain language and there is ambiguity in it, in some states, it's as simple as there's ambiguity, we construe it against the drafter, we construe it against the insurance company. That's it, no other steps. Can't figure out the plain language, multiple constructions are reasonable. The one in favor of coverage is the one. Like, still don't look at all the intent. There's other variations of that where, like California is going to have you look at the reasonable expectation of the insured at the time of policy placement. That's your standard when you get to an ambiguity in California, but only when you get to an ambiguity, you have to get there first. So back to what I was saying, there's a temptation among new lawyers in particular in the US to jump right to there's an ambiguity, construe it in favor of the policyholder, construe it in favor of coverage. But through practical learned experience, having gone through a bunch of these, you start to realize the courts don't want to do that. They want to stop with the language that's right in front of them and figure out that. And so where there's, in my opinion, sometimes multiple reasonable constructions, courts will often still find a plain language interpretation and apply it. And sometimes they surprise me and they find the one that's favorable to me when I thought they might find the other one. But they do try to get it done there.
Hmm.
That being said, it's an interesting facet of how a coverage dispute goes because that policy construction issue is very much a legal issue, one that we'll talk about on another slide in a second, is resolvable by the court. U.S. is a right to a jury trial jurisdiction, though, even in civil cases. So the impact of exposing an ambiguity and now sending you down the route of reasonable expectations of the policyholder at the time of placement or something like that often has, and I think this is part of the reason why they want to find the plain language. That decision often has the implication of now there's a fact question and now there's a jury involved and we have to present evidence to the jury about the reasonable expectations of the policyholder at the time of policy placement. Talk about a thing you don't want being decided by 12 of random people from the county that your court's in, right?
Yeah.
So
Hmm. Interesting.
Cool. And I think from my perspective, just jumping in there briefly, I think what's been particularly notable about exploring the differences of interpreting policies here is that this isn't an academic exercise. And that's, of course, this isn't the forum for it, but that's what we saw with the fallout from the decisions on leg 3 in the States a couple of years ago, where you are looking at policies and wordings that are used all over the world and in different insurance markets with a common understanding of how those policies are to be interpreted and what the clauses mean, and to see that for a judge to make a determination that's at odds with how the other jurisdictions would have come out in terms of understanding how that's to be interpreted. Was it just shows that this is pervasive, and it can have global repercussions.
Yeah,
Mm.
and no better example of that than the issue that sort of united our two firms in the first place, which is
Right.
the leg three case law,
Leg three,
builder's
yeah.
risk world. I mean, we basically realized that, there's two relatively recent still opinions from federal courts in two US, well, one US state and Washington, D.C., um, talking about that, and like four courts in Denmark who have talked about leg three, and that's it, right? Um,
Mm.
yeah, I mean, that's a subject of a whole nother discussion, but I think everybody would love if all of these courts had the ability to. I think it would be great if the court in, California, who's considering my language, had the opportunity to see how the market intended it to be, how it was advertised, how other courts around the world have applied it. Not necessarily as determinative, but at least be able to consider it. And often you're not even in a position where the court can consider it procedurally.
Mm.
Thanks both. Moving on to the litigation phase, which I think we know from films and TV shows is one of the most contrasting phases of the process in the UK versus the US. Will, could you describe what the initial stages of litigation look like in the US? And I'm particularly interested myself in the discovery process because from a UK perspective, it seems incredibly intense.
It is. And I hope that when we talk about watching each other's legal processes in films and such, I hope you're not watching Suits in the UK, because that's a
No.
horrible representation of what it's like. But one that everybody talks about. So again, this piggybacks off an earlier point, but I wanted to emphasize again, there's a very low barrier to entry, and that's important here because it means that the parties may know very little about each other's positions at the point where this thing enters litigation. With the policy, with the burden of bringing a lawsuit or bringing litigation over a coverage dispute, basically just being that the tender has been made, maybe that there was a denial. The insurer especially has had very little opportunity to see what information is available to the policyholder, what's leading them to bring this, to feel that the denial was so wrong, or to feel that they need to bring an action to expedite the process of getting a decision if it hasn't already been denied. Um, and I'm not necessarily saying that I advocate for, as a policyholder lawyer, doing it that way. It very much depends on the claim. If you're in the beginning of a really intense underlying litigation and you really desperately need a defense and your insurer is not providing it quickly, sure, it might make sense to bring this case really quickly. But if you're dealing with a big, complicated, builder's risk, construction all risk type dispute, there's a lot of benefit in the policyholder side to, getting some experts, coaching the insurance company about the information you have, that kind of thing before you bring this case. But nevertheless, many of them get brought quickly. So the discovery process in the US is both sides' opportunity, obviously, this isn't different, but both sides' opportunity to learn whatever there is to learn about the other side's case. And the US gives you some pretty intense tools. So obviously there's all the exchange of documentation. That's not different. Although I will say there's really no, other than establishing that there's some, it's not even a standard of relevance, but like reasonably likely to lead to the discovery of relevant evidence. As long as there's that connection, it really doesn't matter if you're talking about a, very low value homeowner's claim or an enormous value, Fortune 500 property claim. Both parties really have the right to as much discovery as they want, to ask for whatever they want, to The presumption is actually in every court pretty much is going to be a certain number of depositions regardless of the case. And then you're applying for the ability to do more if your case is enormous. Um, but so you've got all that exchange of documents. Coupled with the exchange of documents, you also get the opportunity to send what we call interrogatories in most jurisdictions, which is a series of questions that we basically demand the other side answer, sworn answers. Uh, and what we call requests for admission or requests to admit, which is basically saying, admit this fact or admit this document as authentic or whatever, which is designed to try to narrow down the number of things you've got to go through the really sort of mundane process of introducing in court later on. Um, so that's your written discovery phase, which is particularly because of the volume of documents in a lot of these, it's a very long and uh, expensive. I mean, all of the discovery process winds up being expensive, but that's a particularly long and expensive process because you're constantly trying to make sure you're not producing things that are privileged, and you've got to put eyes on a lot of things in order to do that. Um, Once you've had the opportunity to evaluate everyone's documents, then we go into the deposition process, which is certainly one of the biggest distinctions between our systems, I think.
Mhm.
Uh, and that's basically the right to, typically it's a day. You get a day to ask basically whatever you want to the other side's witnesses. Um, and, in trial, you're subject to fairly restrictive rules of evidence. At least, we carve out certain things that you can't ask. In deposition, you can ask anything you want, pretty much. I mean, you can't force the person to disclose things that are privileged, for example, but pretty much anything related to the claim you can, or related to their character, related to their background. It's a really intense process, and there's a lot of prep that goes into it, depending on the witness you're talking about. Um, because that person is going to sit there and they're going to get worn down over the course of 7 or 8 hours, and you don't know if they're going to ask the really important questions 6 hours in or 1 hour. And sometimes that lawyer on the other side is friendly. There's a lot of gamesmanship that goes into it, and a lot of different styles. There's people who do a really good job trying to get the witness kind of to like them, to be on their side, to open up. Um, and then there are lawyers that just go to war in that room, and they're just there to just basically beat down the other person into submission over the course of the day. And getting somebody ready for that, especially somebody who hasn't done it before or isn't familiar with the process. And I just had the experience of dealing with a client headquartered in Germany, and our person most knowledgeable, which is sort of the person who speaks for the company in the deposition process, was a German uh, individual. And I'll actually say I think the Germans might be the best suited people in the world to depositions because of that, like that dedication to procedure and that dedication to rules, and like she crushed it. She did a great job, which was awesome. But I've had just as many instances where somebody who had no exposure to the process came in and was just completely overwhelmed and taken aback by what they had to go through. Which
I can't
makes it
imagine anything worse, Will. It sounds absolutely
It's
horrendous.
awful.
That's
Some people love
awful.
them. If you're the type of person who likes to go to battle in your litigation, like really go into battle, that's an opportunity to flex that muscle. Um, it also makes it a great settlement tool because at the end of the day, people really don't want to go through that process. And I'll tell you who really doesn't want to go through that process are underwriters and adjusters in London.
Hmm.
When I've
Right.
got, one of these builders risk policies with a subscribed quota share of 8 adjusters in London, I'm noticing all their depositions for sure. And you better believe a lot of these cases settle right around that time. Um,
Yeah.
And
Right.
then we do the same thing with all the experts, right? So you do all the document discovery, all the depositions of all the regular witnesses, and then you exchange expert reports and who your experts are going to be, and you do it all again with the experts. And that one is, if you get to that point, then, sometimes the experts move the needle in terms of resolving it early, but generally speaking, if you get to that point, you're probably going towards the end stages, moving towards trial. The one piece I didn't hit on already, there are limited opportunities to get out of the case before trial in, non-settlement opportunities. Right after the pleadings are filed, there's an opportunity to attack the pleadings and say, you haven't validly stated a claim that you could recover on. Not too many insurance cases are dismissed there. But then the motion for summary judgment, which often happens around the end of the discovery period, that's an opportunity that often results in either actual resolution of the case or sort of practical resolution of the case that ultimately drives settlement. That's the court's opportunity to say, all right, the parties have developed this evidence. They each say that certain facts are undisputed, and the judge can basically look at that and say, I think that there are sufficient undisputed facts here that I am able to render an opinion, a legal opinion about this case. I'm able to rule on questions of law here that will resolve an aspect or the entire case based on the facts that the parties don't dispute. And because so much of insurance law is just like I said, the plain language of the policy, what does the policy mean? As long as the court's not finding an ambiguity and inviting, a likely disputed fact question, court's pretty likely to resolve the case on the language at that stage. So a lot of
Great.
cases either resolve or settle right around there.
Great. Joanna, I know people have said that the UK disclosure process has become unwieldy in recent years, but I still don't think it's quite as extensive as discovering in the US by the sounds of it.
Yeah, no, I mean that's certainly a big difference. I mean, here we do have, some would say it's going in the wrong direction, and I know that there are moves afoot to revisit the extent of disclosure, because now even in some of the smallest cases, you would, with the volume of emails, it's very difficult to do anything proportionate to the quantum, particularly in smaller cases. But just if we just move on to the next slide, Abby, and just picking up on a few of the other key differences. I think one of the points Will was making was about barriers to entry, and certainly I would say that the threshold is a lot higher here. Litigation isn't something you embark on lightly. There's not just the £10,000 court fee, but the exposure to adverse costs and the need to plead with a level of specificity. That means you really do need to have all the detail and the documents at your fingertips in order to be able to make your claim. And I think coupled with that, and as we've touched on, of course, is that we have the split profession here with solicitors and barristers. So in order to get your claim underway, you're likely to have had to instruct a barrister to draft the pleadings, kicking off the start of the claim with the claim form and particulars of claim. Then the reply that follows the defence drafted by the defendant's barristers. So there's quite a lot of front loading in terms of fact finding, in terms of a cost. And again, it's not long after you've issued proceedings and gone through the pleading process that you have the first case management conference, at which point you're already into the thick of working out what level of disclosure you're going to need, which means again that comes with the associated cost. But Equally, I couldn't be more delighted that we don't have an equivalent of the deposition process, that our witness statements are taken in writing from our witnesses who aren't cross-examined until they get to trial. And I think picking up just on Will's last point about experts, I think that is an area of similarity in the sense that it is strong technical evidence can unlock a resolution. Although our experts have an overriding duty to the court, which I think is different in the States. And again, those experts are not subject to a deposition, but their first real cross-examination comes at trial. So in some ways, there's some superficial differences in terms of the process and the stages, but equally, it's a whole world of difference out there. And I think I know where my bread's buttered, and it might not be in the States.
Me too. And staying with you, Joe, because in the UK, even though many of our pre-action protocols require parties to at least consider alternative dispute resolution, and as a firm we do lots of mediations, it's still not a requirement. And in your recent experience, certainly being heavily involved at the forefront of the COVID-19 business interruption litigation, an unprecedentedly high volume of insurance disputes have gone not just to trial, but to the Court of Appeal and the Supreme Court. So what's the reason for that? And has there been a move towards litigation in the UK?
So I think it's really been a perfect storm in recent years. And I think, the three key drivers of that are on the slide. And behind it all, you won't be surprised to hear is really how high the stakes have been from a quantum perspective. And we've dealt with these three big matters that have effectively had such an ability to impact on hundreds of thousands of policyholders, and with a quantum of in each of those on the slides, whether it was the COVID-19 business interruption litigation, the Russian aviation litigation, or the Building Safety Act legislation that we've had in relation to fire safety issues affecting buildings in the UK. They've really meant that it's been harder for insurers to settle claims, and there's a sense in which they don't and aren't able to favour one policyholder over another, so they're looking to take a consistent position. But with the scale of the losses that the sector has been facing, there's been a need to have some court determination in order to guide the settlements that followed. That said, equally, there's been once the decisions have come out in certain cases, and cases are on their way to the Court of Appeal and so forth, there's been plenty of scope to leverage a mediated settlement at certain key points in the process. But absolutely, we've seen a lot of litigation in recent years. Whether that, certainly we're coming up in a couple of weeks' time to the COVID-19 limitation deadline. So it remains to be seen whether this high level of litigation in an insurance context continues in the years to come. But mindful of with an eye on the time, I'll pause there and hand over to Will.
Yeah. The majority, I would say probably by far, and let's go to the next slide, but I think the majority by far of insurance cases in the US do resolve in mediation. What mediation has changed, I would say. Pre-COVID, mediation was very much an everybody show up on the day of at a room somewhere, and that usually meant an adjuster flying in and hoping to be able to get out in time to catch their flight, and that had impacts on the likelihood of settlement, all those considerations, everybody being uncomfortable in that room all day. These days, most of those mediations are now by Zoom. And I don't think of them anymore as a day process, really. There are still some that settle that day, but a lot of them have turned into these kind of protracted mediation processes where, there's a day of mediation, yes, but is it really going to settle that day? It often doesn't. The mediators often kind of work in the phones in the background for the weeks and sometimes months, sometimes years to follow. Sometimes resulting in more mediation sessions, sometimes just resulting in, kind of having conversations in the background, and then he's got a deal together. Um, there's typically an ADR, alternative dispute resolution requirement of some sort in almost every court. Some of them give you an option. Some of them say you have to use, private mediators. Some of them have these concepts of mandatory settlement conferences, which are basically a mini mediation with a different judge in that courthouse. One we're starting to see commonly now is this concept of an early neutral evaluation. The Southern District of California Court just down the street from me requires this, and they basically say, beginning of the case, you got to go in and present to, another judge in our courthouse, what this case looks like and get their thoughts on it, get their evaluation. And that does have some value in driving settlement. But also a strategic aspect from the courts, I think. I've had a good number of judges now who won't set a trial date for my case until um, we get to a certain point in the case. Often the summary judgment motions are filed because they know in insurance cases in particular where the likely settlement points are. And so they want that pressure on the parties to try to resolve it by that point. And they're often right. It often works.
Hmm.
Uh, so definitely, I think at this point, it's not even a trend. I think it's pretty much every court is requiring some form of participation in ADR in the US. But what that is varies depending on where you are.
Right. And just going to both of you really quickly, because I'm conscious of time. At the
Yeah.
end of all the pre-litigation and discovery phases, if the parties have not yet settled, there's still the prospect of a trial. Can you just both tell me very briefly what the trial process looks like in the UK versus the US? And we'll start with Will.
Yeah, I mean, the biggest difference by far here is going to be the jury trial, I think.
Yeah.
We get a jury trial in civil cases in the US, which means, you're putting up the insurance company in front of a jury who, doesn't see great press coverage about insurance companies on balance when they're watching the news. They're hearing about,
Mhm.
insurance practices around hurricanes, insurance practices around wildfires. The news is not positive. So as the policyholder lawyer, I think that's a valuable benefit in our system. We're not arbitrating a ton here unless the policy is requiring it as a provision, an arbitration provision, which is usually something I see in property claims, and not so often in our other lines of insurance. Um, and you generally have a right of appeal in most cases, but never to the Supreme Court because again, no federal insurance law.
Got it. And in the UK?
Yeah, so just to wrap up, I think the big difference is we don't have jury trials. Costs is obviously huge. We don't have punitive damages here, and the loser pays the winner's costs, though there is the prospect of indemnity costs. And arbitration is a common way also of resolving disputes. But I think that takes us out of time, Abby.
Unfortunately, unfortunately, I could chat about this forever, but
Right.
Joanna and Will, thank you so much for your time. I'm sure I speak on behalf of everybody when I say that this has been an education. Um, we did have one more question in the chat about the Merrickville case, Joe. Just if you could provide any further information on that, but I'm sure we can follow up with that
Follow that
person.
up offline.
Yeah,
Absolutely. Very happy
great.
with that.
Thank you so much for joining us,
All
everyone,
right.
and the recording will be out tomorrow.
Perfect. Thanks, Abby. Great
Thanks,
talking
everyone.
to you.
Bye.